What a wonderful location to be in the midst of artwork, to be talking about art and intellectual property tonight. I'm really excited. I'm also really excited to be talking in Falls Church. I live and work in Falls Church, so to be able to give a presentation to the community and surrounding communities is important to me, and I hope you'll take some valuable lessons from it. And we'll certainly take a lot of questions at the end, and I'll stick around at the end if there's additional questions. I've got an image here on my slide, if I can get it to work. There we go. That was pretty well known during the last election cycle. Actually, there's primary elections today in other locations, but I wonder how many of you are familiar with this image? Great. And does anybody know who might own or claim rights to that image? AP is one of the involved interested parties, yes. It's actually got a complex story that is in litigation and negotiations. Still, well, for lawsuits, a year or two is nothing. It, as you can see here, is based on an actual photograph from a speech or a presentation that then Senator Obama was at. And the potential people who have a claim to this well-known Hope image are the photographer who took the photo, the Associated Press, who the photographer was working for and was being paid on assignment for at the time he took the photo, the poster artist who then had the idea to take this photo and make it into this cartoon, or however you want to describe the image with the colors and the red and white and blue. And in addition, the campaign of Barack Obama that then got the image from the artist and used it on posters and other promotional materials, I think t-shirts and other things and banners. And so you've got four interested parties there that all have some claim to this intellectual property. And this serves as a backdrop to the significance of intellectual property and the complexity of intellectual property rights, and to the dangers of intellectual property if you don't focus on protecting it and identifying it and putting it in writing when you have contracts and negotiations between parties from the start. All of that could have been avoided, for sure. So, for artists in particular, intellectual property really is at the core of what an artist does. Intellectual property is really about protecting things that are unique creations. And being an artist is really about creating things that are unique, regardless of the format or the medium or the size or the scope, or whether it's just for to hang on your wall or your friend's wall, or whether it's to hang in an art gallery, or whether it's up for sale for a small sum or a big sum. Art is about creating things that are unique, and intellectual property is about protecting things that are unique. And so they really are very important to each other. And I hope that today we'll all gain some more appreciation for the value of intellectual property in the art community. In terms of protecting intellectual property, there's three main types of intellectual property: copyrights, trademarks, and patents. And we're going to discuss each of those in more detail later. But in terms of an overall framework for protecting intellectual property, the important steps are to identify intellectual property that's being created or has already been created, to notify others when you're using the intellectual property about your rights and the copyright or trademark or other rights that lie in that intellectual property, to register important intellectual property when applicable and when possible, and to include provisions in contracts with partners or employers or subcontractors or other relationships around the artwork. Contracts are often overlooked, and if there's anything that I leave you with today, I hope it's that Contracts in writing and knowing what the contracts are essential. And let me say I have brought some printouts of the slides, so don't feel too obligated to take detailed notes. And I'm happy if anybody wants at the end, give me your email address. I'll email you the PowerPoint. And a lot of this information is on my website as well. So I mentioned the first step is identifying your intellectual property. Well, intellectual property, it comes in any format imaginable, okay? Traditionally, classically, over the years, we can think of the basic things of music and text and paintings and drawings and sculptures. But it's any creative, artistic being. It can be film, it can be audio, it can be computer software. Computer games are a type of artwork these days. Other computer programs are types of art that are protected by copyright. It can be performances, staged performances, theater, both the scripts for them, the text, as well as the actual stage performance of an event or of a theater production. Fashion designs are a type of intellectual property that have some subtleties to their protections. But these and many more are types of intellectual property that artists create and need to think about identifying and then taking the steps to protect and notify others about. Another way that we can identify intellectual property that's been created is in marketing and in promotion. So that might be in the form of an advertisement, a flyer, a picture, a video talking about a piece of art. All of that becomes another layer of intellectual property. A website promoting a gallery or promoting an artist's work or an artist's series of sculpture. The website itself is a separate piece of intellectual property that needs to be identified and protected. Creating newsletters that talk about your intellectual property, or having a Facebook page or some other social media interaction that talks about your art could also be a separate form of intellectual property. All of that content on a Facebook page or another type of web social networking page is intellectual property. So the first step is, again, identify where you have intellectual property, and I think you realize that you all have a lot of it. I mentioned the three main types are trademark, copyright, and patent. Copyright is the right to the work itself, a sculpture, to reproduce a sculpture, to make derivatives out of that sculpture, and to prevent somebody from copying it substantially exactly. And again, I'm using sculpture as an example there, applies to any form of art. Copyright protection is actually, it's sort of born in the work of art whenever it's completed and it's created, without anything further done, without telling anybody about it, without filing anything with the government, without putting it in the writing. The day I finish a doodle that is unique and original, that is protected as something that I've done and is unique, and there's some copyright protection in it. Now, I can greatly enhance the protection in it if every time I display it, every time I talk about showing it to somebody or selling it or presenting it, I put a copyright notice on it. The more prominent, the better. Proper copyright notice you can see on here is something like copyright, C with a circle, 2010, the name of the creator, or the company if there's an entity, and then the phrase all rights reserved, which is important in certain international aspects. So now I've not only identified a work, a doodle, I've added my copyright notice to it, across the bottom, or if there's a web page, maybe even across the top, or maybe even before the link to get to the piece of art. It says, the page you are about to enter contains work which is copyright 2010, Eric M. Pelton and Associates, all rights reserved. You really can't use the notice too much. If you have photos, they should be embedded in the photos or on the back of the photos or on the albums some way connected to the photos. Obviously, in a print that you're selling to somebody else, it's not going to be embedded in the photo. But if you can do it digitally, so it's not reproduced without your copyright notice, or if you can attach it to the file, or again, if you're emailing it to somebody prospectively to look at, if you have a copyright notice in that email, at least you've now taken the step to say, not only is this something that I've created and it's original and I'm claiming copyright notice in it, but now you understand that this is something that is important to me and I've identified as a piece of work that's mine, and that's going to help really frame the discussion with whoever the viewer is to understand that this is art and this is important and you claim this as being yours, and hopefully that scares off people from trying to copy or pirate or misuse it. And if in the event that there is some sort of misuse or situation, gives you a much, much stronger claim to say, you knew that I was claiming that this was mine. Here's the notice that was attached to the work. Registration of a copyright is fairly simple. It costs about $50. You can get the forms from Library of Congress. Their website is loc.gov, or I believe also copyright.gov takes you there. And it's a pretty user-friendly form, and any work of art, you can submit a copyright registration. Now you have to deposit samples of the work to the government, and there's information there about samples. You know, sometimes if it's a sculpture, you're not going to drop off 2 giant sculptures. First of all, there might only be one unique one, but you could take photographs basically, or you use the sketches that went in, you know, that were prior to creating the final product. So you don't have to register everything, because if you generate a lot of art, that could be a little tedious, but I encourage you to identify some representative materials or your most important or valuable materials and register a few of them. And then that way also you can tell people, you know, you can brag about it in your materials. Hey, these are registered. That, you know, now it sounds even more important, more valuable, and the protection that you're asserting carries that weight that you're communicating to the audience of the work, that this was important enough to me that I registered it. You know, that really adds to the value and helps prevent situations.
Eric, do they get back to you and tell you that you have a copyright, or it's automatic?
Great question. They do get back to you, believe it or not. It takes them currently anywhere between 6 months and 2 years.
Oh, really?
Yes. If you file purely electronically, you get a quicker response. But oftentimes, if you file on paper or have to submit physical attachments, their backlog is so bad that it takes 2 years. But of course, the rights really were generated when it was completed, and it really doesn't matter when you receive the registration. It really just matters that you have filed to register it, and that you have used the notice since it was created.
So you can say registered.
Well, you can't say registered until it's registered.
Oh, okay. That's what I wanted to ask.
Yeah.